So in the last few days, we actually noticed that the circulation of data and also the accessibility to data is actually a pretty much important aspect to take into account. This is the reason why it is important to also know few aspects about the legal landscape governing the data, especially the personal data, and especially in Europe. So the legal framework is particularly broad. We have areas about data protection, we have areas regulating the sharing of data, and we have also different new rules governing artificial intelligence. So taking into account the data protection, we need to bear in mind that there are different interests at stake when it comes to data protection. On one hand, we have the interest of the circulation of data. On the other hand, however, we have also the interest to protect the data. The right to data protection is basically the right to any person to have a full control over his or her data, meaning that when this control is given to other people, the physical person needs to know who is the one who is in control of his or her data and actually who is or what is the processing that's actually going with it. So the matter in Europe is regulated mainly by the General Data Protection Regulation and the different national laws, but sometimes specify and give specific requirements in general for the single member state. It's important to notice that the General Data Protection Regulation provides for a definition of what a personal data is. Personal data is any information relating to an identified or identifiable natural or physical person. This means that not only the name and surname or the home address are to be considered personal data, but also information that at first glance seem not directly connected to any kind of physical person. An example in this respect is provided by the pseudonymized data. Pseudonymized data are information that, again, at first glance, they seem to be actually anonymous because we cannot refer them to any kind of person. However, if we have technical operations, if we make technical operation over that specific information, and we are capable to link that information to a physical person, then such pseudonymized data is to be considered a personal data. To give an example, in the first chart we see names. Names are actually common personal data. They go through a processing that makes them pseudonymized, and we have a string made by numbers and letters. At first glance, apparently, it seems that these strings should be considered anonymized. Actually, they need to be considered personal data because we have a technical operations. We can make technical operation over such specific strings so that they can reconnect or they can be linked to a physical person. This means that the GDPR not only applies to James and Christine names, but also to a string made of numbers and letters. So, provided that this is a broad definition of personal data, what is an anonymous data then? Anonymous data, on the contrary, is an information that we cannot reconnect to any kind of physical person with any kind of technical operation over it. When we are actually processing anonymized data, we are not actually taking in consideration the regulation about the general data protection. So, since we are talking about information that directly belong to the single physical person, we need to know when we are actually doing operations with data. And according to the GDPR, to be simply put, in any case when we get in touch with data belonging to other physical persons, we are actually doing a data processing. For example, also the anonymization is a processing. The consultation, the transfer of data are to be considered data processing. So when we are actually using information belonging to other physical people, we need to have a legitimate reason, legitimate of course according to the law, according to which we can actually use and process this information for our economic and professional purposes. So we need a legitimate basis. The four most important legitimate basis is of course consent. Consent needs to be informed, needs to be clear, needs to be unequivocal, needs to be given by the data subject itself. However, the European legislator recognizes, of course, that sometimes it's difficult to ask directly for consent to a data subject. But this is the reason why, for example, in healthcare, when, for example, a physician is actually taking care of the healthcare of a patient, he or she doesn't need to ask for consent. This does not mean, however, that the data subject does not need to be informed about the processing and actually who is carrying out this processing. It simply means that you don't actually need to ask for the consent of processing his or her data. Another example that maybe is more on point given the scope of this summer school is, of course, the scientific research purposes. According to the General Data Protection Regulation, we need to look at what the union law and the single member state laws have to say about the processing. This means that sometimes also the rules can be different from member state to member state when it comes to research and processing data, personal data for research purposes. Given the fact that the framework is quite complicated, the European legislator tried in the last few years to improve the data sharing. The access of data is actually one of the most important aspects of the data protection as well, because of course it's needed in order to improve and develop in the market and in the new technologies areas. This is why the European legislature actually proposed different kind of regulations trying to improve the data sharing. One of them that's coming into force in September is the Data Governance Act, that's actually trying to improve the sharing between data that are being owning by the public entities with the operators, private operators that are actually interested in processing them. Then we have, of course, the European Health Data Space, but this is a proposal about creating such platforms for accessibility of data for reasons of healthcare and scientific research purposes, such as, for example, also training of artificial intelligence. Last but not least, of course, we have the Data Act. That means improving the sharing of data between private operators and private companies. So I will now a bit focus on Data Governance Act since it's coming into force, as I said before, in the next months. So these regulations actually tries to, as I said before, make accessibility of data from public entities to the people that are actually interested in processing them through the setting of different conditions for the so-called reuse, meaning when the data that are already being collected for a purpose are being actually used, so reprocessed for another purpose, by a different person. But at the same time, the Data Governance Act aims at improving also the connection, the links between the data subjects and the people actually interested in processing those kind of personal data. Through, of course, the data altruism. With data altruism, what is going to be done is basically that the data subject will provide for consent in order for his or her data to generally be used for reasons for general interest purposes. For example, scientific research for improving healthcare, scientific research for combating climate change, and so on and so forth. I think it's worth to mention also the European Health Data Space. The European Data Space is still now a proposal. It will be a proposal for quite a long time because it's now being discussed between the Parliament and the European Council, but tries to strengthen the accessibility of data, of health data, first for the data subject, especially when data subject is in a hospital different from his own national state. And at the same time, it provides for platforms capable of make data, personal and non-personal data, accessible for people who are actually interested in processing them. Again, this actual proposal aimed at improving data sharing, also taking into consideration the fact that we cannot use data without any kind of limits given by the right to the data protection of a single data subject. Last but not least, the European Union decided also to give some insights, some proposals about the artificial intelligence. As it was mentioned yesterday, the artificial intelligence is actually improving right now. It's becoming a reality in everyday life. So the European Union decided to actually proposing a regulation and a directive trying to give in rules both when the artificial intelligence is being developed and also used professionally, but also when, for example, damages may occur in using such artificial intelligence. This is why the Artificial Intelligence Act aimed specifically at giving specific requirements, for example, in the development of artificial intelligence, for example, when it comes to giving the human always the command over the machine, or giving, for example, an explainability of the operation elaboration of a machine itself. On the other side, the proposal for a directive gives a specific, we could say, guidelines about the civil liability. So when a damage occurs due to a malfunctioning or due to lack of outputs from artificial intelligence, who is the one that is actually to be considered liable? And who is the one who actually needs to repay for the damages? So this is all a broad insights about the legal norms right now and in the future that will be applicable to data and, of course, to artificial intelligence. With this, I conclude, and I thank you for your attention.